Our next order of business is Elizabeth Reese. This is regarding 7 Thompson's Road, Saugerties, New York. The SBL is 18.14, 5.100. This parcel is zoned industrial with aquifer overlay. The applicant is seeking an interpretation of the building inspector's zoning administrator's determination dated March 11th, 2025, classifying the proposed BESS as an electric service as defined in the Saugerties zoning law and therefore being permitted in the industrial zoning district by special use permit and site plan review. Assuming you have something you want to say.
Actually, not really. My understanding was that I had to appear at this meeting in order to be able to have the appeal fully accepted. So that's why I'm here. I'm not clear what I need to say, or my understanding is that there is no timeliness aspect to this appeal because this interpretation hasn't been formalized. We did try to get copies of the formalized file determination, and we have not been able to. So from what we can tell, timeliness has not started. That's all.
I'm not sure I understand what you're saying with respect to that. Can I ask you, so everybody's clear here, and I think we understand. You have 60 days now. Typically, it would be 60 days from when the determination was made to appeal from that determination. We have looked at this, and there is some standing to support your timeliness question based on publication guidelines for application to the Zoning Board of Appeals. This is published by the state for people that have to appear before the zoning board, and just to get this on the record. There is a question in here. I am a resident who lives near the proposed project. What happens if I find out about the project more than 60 days after the permit is filed? If you are a third party, which you are, such as a nearby resident, you may still bring an appeal more than 60 days after the permit is filed. If you file within 60 days after you've had reasonable opportunity to find out about the planned project. And I did discuss this with our town attorney, zoning board attorney, who unfortunately could not be here tonight, but there is legal precedent supporting this. So I guess the first question I have for you is, when did you first find out about this?
In January.
Do we have a date?
Because at the town board meeting.
And how did that come about?
The supervisor discussed it.
So you were just at the town board meeting?
Yeah, I go to a lot of the town board meetings. I used to film for about 7 years for TV 23. So I make a point of, the reason I film was to make a point of showing up so I could pay attention to what's going on in my community. So I do attend a lot of them. But since I submitted this application, I did try to find a record of that zoning determination having been filed, and I could find no record. So I went into the town office to see if we could get access to find it. And my understanding from the person we spoke to is that it has not yet been filed at all. So the countdown hasn't started.
See, I don't understand what you're talking about filing. I don't understand where it would be filed. It's been in the building department's records since the determination was made.
Well, that's the whole point, though. We have nothing to show that it is actually filed in the building department's records. And the only letter that we have is actually a letter from Key Capture to Alva there's nothing that's a formal determination on town letterhead to say that this is the determination.
We have a letter on town letterhead.
It's
I believe you had that actually
On-
attached.
right on key capture. It's a key capture letter. It's not a formal determination issued by the town.
No, you had a letter from, you had a determination letter attached to your application.
No, hang on. Let me see which one. I can't see from
The town's determination letter is attached to your application.
which one. Let me see which one you're referring to. This is the one that I have regarding these two packets.
Yeah, but the one behind it, you had attached as well, that is the building department's
Right,
determination.
but that's about the different lots.
It's the same, it's to the same company. They have changed their lots,
But
but
it's
it's the
not-
same company.
This is not the lot that the facility's going on, that's a different lot, and it's not part of my appeal. I'm appealing specifically these lots, and that is just one of two lots that are part of the applicant's application.
But it would be the same determination, right, Albie? Yes.
But that's not what I'm appealing. I'm appealing these particular lots and the initial determination.
But they're still located within the
I'm
same
not-
zoning district. So the determination would be the same, correct,
Sure, am I
Albie?
supposed to be having this conversation?
Well, we're just trying to get to the
Right.
bottom of this.
This is what we're, this is why I'm appealing. Specifically, the lots that were listed in this last lot, which are two lots, this one and this one. This second, and it's not, none of this is on, Saugerties, I'm sorry, on Saugerties town.
It's signed by our zoning office.
I could find no proof after I asked for it numerous times that this would be found, including going into the office, somebody looked at records and said it hasn't been filed. I spoke to a girl on the front desk, and I went to talk to her and asked for a copy and to inspect files, and she said, the determination has not been finalized, that's what she told me. And this is about a completely different lot, so,
Well,
this wouldn't be possible if this.
Anytime we make a letter like that, it becomes town record. It's been filed in the town record, and when it's foiled, that's how she got a copy of that letter, because she requested it and it was sent to her.
I mean, at this point, I don't think the letter really even matters to what we're being asked to interpret, because before we can even move forward with this, we need to determine if this is final. And unfortunately, we're having a hard time with dates, I guess.
What we need the dates and the determination.
Could you repeat? I didn't quite hear the final summation of this without microphone.
The determination of the building department was issued in March of 2025, so the time to appeal from that has long run. But since we have a third-party appellant, we need to determine if she had knowledge within the past 60 days of this project, and we're having a difficult time doing it. You are here on behalf of the project developer, correct?
I don't know.
If I'm allowed, I can.
Yes, yeah, I mean, we gotta get to the bottom
Excuse me,
of
is this normal procedure to have this?
This is not a public hearing, but I'm not gonna preclude them from speaking, because they have a vested outcome, a vested interest in the outcome of this proceeding. And we do typically allow people that are directly involved to speak.
Thank you. Attorney Hyde Clark with Young Summer here on behalf of Casey New York 34 LLC, which submitted the request for the zoning code interpretation, which was issued March 30th, 2025. As the chair noted, that was filed as of that same date. It was sent to the building secretary, the clerk, planning and zoning, as well as the town designated engineer. The question as to when there's knowledge in the actual application, there's a representation that it was based on when we filed our full application. So we included our interpretation determination in our full special use permit and site plan application, which was December 9th. So we're also beyond 60 days there. In terms of potential tolling, it's my understanding that would be for an aggrieved party that may be next to a project. This was an interpretation of a particular use, not a specific project. So while there may be tolling if this board issued a special use permit, you didn't know about that special use permit being issued, perhaps you can toll that time period. I'll reserve the right to submit additional as to whether or not the tolling would apply in this situation, but we don't think that it would be appropriate to set a hearing for this time. So that's our position. Thank you.
Input from our,
I see what the applicant is saying about the SBL, and I'm just trying to, I was about to pull up the parcel viewer to see what parcels we're talking about. Yeah. So I'm not clear on which parcels are being questioned.
We are not taking questions from the floor this evening.
It's a brief, very brief comment.
No. You get to do that next month if we move forward with this.
Thank you.
Holly, it's over there behind the AutoZone building where the Lyman School is.
Oh, I know where it is generally, but the SBLs that are on the application for interpretation are 1814, lots 18-110 and 5-100. And the SBL on this letter from the building department, March 30th, 2025, is 17.16 to 25-110. Maybe that's a typo, or maybe that's another lot that is owned.
That would probably be the building itself that's owned
Or
by
an
the
exhibit,
same
okay.
person, because I think it's, yeah. Because the SBL on there is probably to refer to the building itself,
Got it.
where it was set to.
And it's not an opinion as to whether, just to be clear, this letter is not an opinion or interpretation as to what is permitted on that site, on that SBL. It is a letter as to what is permitted within the industrial zone.
So the bulk of the data. Is that right?
I think any lot that's reflected here is within the industrial zone.
They all are, then they're all the
They're
same.
all.
Okay, that was my only question.
So before we can do anything,
I mean, I still don't feel like we really know exactly when you learned of this facility.
Oh, town board meeting.
Right, we asked you that, and you said, I think it was at the town board meeting.
Yeah, it was the
at
town board
the
meeting.
or
I just went
before?
back into my calendar. It was at the town board meeting in January, because that was when we asked Fred about it, and he said that he didn't know about it himself until very recently.
How did you know to ask Fred about it if that meeting is where
Lots
you
of people,
learned?
a lot of people were talking about it.
Was
so.
it on the agenda at that meeting?
What, was it on the agenda?
No,
Huh.
it had been in certain news outlets.
Can I have your name?
My name is Tanya Trippi-Weiss.
What was the date of that meeting? I wasn't there.
January 7th.
No, January
Right.
21st. The January 7th meeting was an organizational
Oh.
meeting that the public didn't attend.
just if I can interrupt you for 1 second, is this the person that you asked that we would listen to?
Yes, sir,
that
I'm
was
sorry,
working
yes,
with
yes.
you?
Is it okay if I speak for a second? I think the question was more.
I'm going to let you speak
Okay.
because Elizabeth did ask me before the meeting
Yes, she had told me that she would.
to represent her as part of this application.
I think a part of the questions with regards to the determination is the March letter that was dated in 2025 for an interpretation of the use of the facility, like what this company is proposing, was not confirmed to be a final determination when we went to the building department this week. We were told that this was sent by them, that it didn't mean anything because it wasn't on town letterhead, that it was just provided and that it would be followed up with. We were told there were 2 applications made for the same property, one in October of 2025 and then this one here. So there's like a lot of paperwork and a lot of confusing things, but this letter from Key Capture is very clear as to what its intention is as far as asking for the determination for the special use permit. But if you go to the E-code, the section that outlines what the type of facility it is, it doesn't actually meet the operations of the business.
You lost me
Well,
there.
we're not
So,
even talking
but
about
I think
that.
that the question on this determination, the appeal to not the zoning, but the use as it's classified, their company as it's being classified for use, electric service, right? The determination, that's what this letter is. We're asking to be classified as electric service. But but E-code 360, the definition doesn't match what their business does.
So that, I think, is a
But
separate question.
That's a separate question. I mean, the only, you are here for an interpretation from this determination. All this board is going to consider is whether or not the use is permitted in that district. I mean, you are appealing from a determination of the zoning officer. And that's it. That's all we are looking at. So I guess our interpretation will be, and you will get your chance to offer that, will be, is this an electric service as defined in the zoning law?
But first, we have to consider the timeliness of the appeal.
The timeliness.
And that's
of
why,
this.
Well,
And-
so when we went to the Department of Buildings to speak about the file that had been foiled for, we got certain documents. We were told that this letter was not, this key capture letter on the key capture letterhead dated March 10, 2025, was just a letter sent by the company, that it didn't represent government operations because it was not on the town letterhead and because it was not part of the application initially.
it is countersigned by our zoning
Yes, I
officer.
understand that it's
And
countersigned.
you do have a letter on the town letterhead.
That it's a different
I
lot.
realize it's got a different,
But there was a different application put in for the same thing that was repealed in October of last year. So I don't know what the town letterhead letter or the key capture letterhead letter, there's an open application, there's a withdrawn application. We can't put together the pieces as to what belongs to who or what, and so we're just asking for clarification.
And we were unable to see any files when we went over there after foiling for them. We didn't get them.
When did you foil for them?
I don't have that timeline necessarily right in front of me. I foiled for them on multiple occasions though. Would have been subsequent to when I put the appeal in.
Okay, so, again, that's then not relevant to the question of whether the timing, whether this application is timely, which we're just trying to get to, because if it is, we can make our interpretation after a public hearing. If it's not timely, we can't hear it at all.
Understood.
So that's the threshold question, and it's unfortunately not a matter of black and white facts,
this
because,
is the problem
yeah.
we're
Could I say something regarding the time?
Excuse me, I'm sorry, why are members of the public able to
He
participate?
was just gonna address
I
it.
was just going
She
to
just
address
asked
that.
Sorry,
No, this is
before
not a
she asks
public
the
hearing.
question.
So if I can ask, your application went in on December 9th, your permit application, is that?
That's correct.
That's correct. It's my understanding that it was asked that it not be put on the planning board agenda until February.
For an agenda, that's correct.
So it does raise the question of when did the public have notice of the project moving forward? I mean, I'll be honest with you, I heard rumors about it. My first actual knowledge that it appeared to be moving forward was when I received the email invitation from the developer to attend a public information session, and that was not till in January for, I believe, they held a public information meeting on like February 4th or 5th.
February 5th.
So we're having a problem reconciling when did this actually become public knowledge?
Thank you.
And we're not coming up with any solid dates, unfortunately.
And may I add something? And this is the problem that we're having too. This is a problem that I'm having too. If we had been engaged as members of the community in a transparent way, we wouldn't be having this conversation.
Well, but that's not for us to determine.
I know, but you understand.
Just on the question about two letters, we had submitted a letter request to the codes officer saying, here's what we think that it would be classified as. That was the earlier March letter. Although that's countersigned on key capture letterhead, there is a town of Saugerties letterhead to my client stating what the determination is for that use. And so I think there's a little confusion because they've seen the KCE letter where we made the initial request, but the actual determination that was filed is on letterhead. And, that's part of the record of the appeal request and as well as what we've submitted. So that's just trying to clear up why there's two letters. We submitted something, said, hey, can you take a look at this? This is what we feel the use is. Yes, that was countersigned, but that wasn't the determination. So that's just to, clear up why there's a little back and forth there. I still think there's a question, there is no public notice requirement. It's, it was a public record, and I think there's a question which I don't think's been laid out in the application as to why the appellants are grieved by this decision. I think, again, the 60-day tolling period that you're speaking of, the case law will tell you we didn't get a notice, public hearing notice that the ZBA was going to hear, area variance application or use variance application, and there's a standard of why that person may be aggrieved. And in this situation, again, there's been no determination on the project where we have a special use permit, site plan review, public hearing requirements at the planning board. And I just think to the extent that a third party could potentially be impacted by the project, that would be the appropriate board to participate with. So again, I just think the 60-day tolling period as an idea is being thrown out very broad, and I don't know if I necessarily agree it applies in this situation. I know you don't have your attorney here tonight, but to the extent that this application's either not ready because we haven't determined when knowledge of it actually happened, whether or not that third-party 60-day tolling period applies, perhaps an adjournment is more appropriate.
So this, and I gotta be honest with you, this is the first time I have ever dealt with a third-party appellant.
Yeah.
So
Yep.
this is new for us. And I had floated the idea with myself, and was going to float the idea tonight that we could put the determination of timeliness off until we can have the attorney review. But of course, I don't want to slow you down, because your client, I mean, this isn't a case where we can mutually agree with the appellant, and then we're delaying you. If you're okay, and you would be okay to mutually agreeing tonight to delay the determination on timeliness, we can come back next month and make that decision.
Sorry. Before I say yes or no, just in terms of like a party, I am affected because I live in the village, and this is going to affect me absolutely. Number one, and then also, if this zoning predetermination hadn't been made, then the applicant for the project wouldn't have been able to submit the application in the first place, because it is our contention that the classification that was used is incorrect. That's the core of the
I'm not sure I
argument.
necessarily agree with that. They could have come forward and made an application to the building department to move forward with the project, and then they would have had to make the determination at that point.
Okay. Okay, I understand what you're
I
saying.
mean, that's what typically happens. Somebody applies to the building department, and then it's found out that they need a variance, or that maybe it's not permitted in the district, and then they have to appeal to the ZBA for that determination.
So that,
They did not have to make a determination. I am sure the project developer asked for it as pre-planning to the project, but they could have come in and said, this is what we want to do, and then the zoning officer would have had to make a determination
right?
as to whether it was permitted or not. I think you're putting the cart before the horse a little bit.
So,
I mean, it's hard to respond when the public is kept out of the process with notification until a later date, to feel like there are options or an ability to trust the process. So if it feels like we're throwing whatever at the wall to stick, it might be because there's a good portion of the people who live in the village who aren't necessarily supportive of this and feel like we have no options to be heard in concerns with regards to like what the impact of this would be and how these things are being proposed with like keeping the public out. This is an emerging market. This is a largely unregulated emerging market. And so our concerns should have a time and a voice. This was one of the few things we could find.
But I don't think anybody is keeping the public out. This whole thing would become public before the planning board process.
But the fact that they asked to delay on notification from when things were put in is concerning. On the agenda, it was just stated that it was asked to be held from the agenda until February 12th.
Applicants do that all the time. I mean, we deal with
So how
that
do we
where
deal
the-
with
when
timeliness
The applicant is
factors?
a project developer.
How do we deal with timeliness factors if agenda items are withheld under timelines?
As the individual who made that request, if I could just comment to that. My name is Paul Williamson. I'm the development manager for the New York 34 project for Capture Energy. And we requested that the planning board delay the first presentation of the project permit to the February 17th time, so that we would have time for public meeting opportunities and public notification prior to the planning board being reviewing the first permit application. And so our full intention from the very beginning of this project was to be open to the community, have public conversations, and provide public information about the project prior to permitting.
If I may, as far as being open to the community, if that was the motivation, then we would as a whole be following NYSERDA guidelines and incorporating that into the process, which would have involved more transparency to the public. But to your question, as far as like delaying the decision, I'm okay with that.
So, I
So
guess,
our position is, we've got 62 days from when the application is received to hold the public hearing. We can delay the determination on the timeliness till next month, but it's gotta be on mutual agreement of the applicant and us. Otherwise, we're gonna run afoul of our 62-day requirement for a public hearing.
I guess if the board's intention is to hold a public hearing,
We
then.
don't know that yet.
We don't know that yet. That's the issue.
We need to research
Unfortunately,
this and consult with our attorney.
You know, your email came in at 4 o'clock this afternoon.
Yeah, we didn't
The
have
building
the agenda
department
till
was
Friday.
about to close. I couldn't get ahold of Becky to.
Is that an email that can be shared?
Yes, we learned about this being on the agenda Friday afternoon.
Yeah, it's a public record.
Yeah,
It's been
it's a
submitted.
public record. They submitted comments on this today.
I'll provide a copy to you, Bob.
In fact, we have extra copies.
Oh, thank you. That would be good. Thanks.
I'll let
Yeah.
you, I don't wanna.
Thank you.
It's the, yeah, I mean, the issue we have here is either way we go, we're potentially opening ourselves up to an Article 78, and unfortunately, as I said, this is the first time I have ever dealt with a third-party applicant that, you know.
It's the first time I've ever been a third-party applicant or even an applicant, so.
But I think the hearing could address the timeliness issue first, and if it's determined at that time that the board is going to consider the request, then at that time, there'd be additional public comments and opportunity to discuss the merits of the request.
I think that if,
Yeah, I'm
I
not
think the
sure.
timeliness is a question for the board and the attorney. We wouldn't, if we don't think timeliness has been met, we would not have a public hearing.
Right.
So that's a threshold issue.
Yeah, I think the way I interpret it is that once we voted to set the public hearing, I think we've then made an obligation to hear the appeal. I don't know how we can shut down, we announce a public hearing, invite the public in here to make their comments, and then shut the hearing down before it happens based on the timeliness. I don't think we can do that. I think we either need to agree to hear the appeal or not.
Yeah.
And I'm open to everybody's thoughts here tonight. You can err on the side of caution, hear the appeal, which doesn't preclude you from making all your statements at the public hearing and presenting any evidence you have to bolster the argument that the determination of the building inspector is correct.
Right, the hearing is not about the timeliness, the hearing is about the definition in the code.
And that is really all we want.
So, you agree?
Yeah,
Yeah.
I agree. I mean, I think, as I just said, I think if we agree to set a public hearing, we've agreed to hear the appeal.
I agree with you.
Forget the timeline.
Yeah.
But we do have the opportunity to have a meeting with our attorney before we can make a determination on timeline correct for this.
As long as the applicant, I mean, they are not the applicant. Our applicant is Ms. Reese.
She has to.
She has to agree with us to delay. My only concern is in that agreement, we are delaying the project developer.
Did he make a comment about adjournment?
Yeah, that's why I just asked. If they're, unless we move the project timeline at this point is out quite a bit. Like, we adjourn the time of this matter till April, and our public hearing will be till May. And I don't know what their timeline looks like.
Should we call him up here and discuss that, or is that?
Their timing is 2030 for completion, they're fine.
I mean, I don't know what anybody else's opinion is here tonight. We can agree to hear this. And discuss the interpretation.
If they don't want, so we need them to mutually agree, so if one of them doesn't want to, then we have the choice.
Can you
Well, but
speak
really-
louder, please?
Really, they're not even involved in this, other than I'm giving them the floor
Well,
as
when you
a
said
part.
mutual, you meant between us and Elizabeth.
And the applicant,
Okay.
yeah.
Got it. Okay. Yeah.
If I can just quickly comment, I understand there's a question before us, and we're just conferring about what the different scenarios related to that question are, so that we can come back and give you an informed response. If that's okay. We just need another couple of minutes here to discuss.
They just want another.
I'm sorry, I couldn't hear what they were saying, what you could hear. I have bad hearing.
They're going over scenarios. They need a
resolve.
minute.
I think they were under the same impression that I was. And you might need to disabuse them of that. But we should just know what we want to do. Give an opinion.
I'd like to hear the developer's position. You can help us with the timeline.
Thank you for your time.
Thank you. No, just hearing from the board, it sounds like you prefer to have the opportunity to have a chance to confer with the attorney and not set the hearing until the following month, which we would be okay with. And, you know, similar to if we had a use variance application or area variance application, you know, we do have a planning board. It's not, you know, your purview, but just saying out loud, there's not really a reason why we can't continue with the planning board process. The planning board just can't necessarily make a determination similar to if we had a use variance application or another application before the board. So, you know, we're okay with the adjournment.
Okay.
Yes.
Yeah, and at this point, I think you could move forward with the planning board, because until we make a determination of whether we're gonna hear the appeal, I don't believe they had stayed you.
Yeah, correct.
But I presume the planning board will not make any final determinations until we have
Yeah.
made a decision and an interpretation here.
And Elizabeth, your friend who unfortunately just left for a second.
She went to the bathroom.
She had asked about timeliness and how could you be expected to comply with it if we're asking you to delay. We're not, obviously, your paperwork is in and we're not gonna, it's not relevant, the fact that we are.
Sure, absolutely. I mean, we're all here in a public forum, so yeah.
Joe, did you have another question? You said-
Well, I said I'd like to hear their willingness to let us proceed before we push them back.
Okay.
And they said they're gonna meet with planning, but slow them up.
Just for the record as well, for something to consider with your attorney is again a standing question and whether or not the appellant's aggrieved by the determination. So, you know, we'll likely submit additional materials on that. Not looking for feedback, just
Excuse
stating
me?
I think there's some other issue here as well, so.
Okay.
Do I have to be aggrieved to be able to put in this question about the determination? Well,
Yes.
I live in the village, so I am.
I mean, you can't just walk in here and say, I don't like it. You do have to
Yeah.
show that you are an aggrieved.
I would much rather have somebody else had been able to submit this, not put me in the hot spot, but I am within distance of that place.
As I said, this is very unusual.
Yeah.
If you were an immediate neighbor, this would be easier for us.
I think I'm like 0.3 miles, so I have a lot of concerns.
I think you're in a position where you are the applicant. If we agree to hear this, you're gonna do the mailings for a 500-foot radius,
Yeah.
and you're not even gonna have to mail to yourself.
Well, I don't think there's many people that actually live within the
So I think
500-foot
the aggrieved
radius.
may be a question.
Well, I may not be within that radius, but I'm certainly within earshot, and I'm certainly within the danger zone that would result from this kind of a project, so close to so many residential facilities. The fact it happened to be just across the border from the village, I live in the village, it impacts our resources, it impacts our water. I don't see anything about the emergency plan specific to our community in the application
And again,
package.
We're not gonna discuss that.
I understand.
Should we agree to hear this,
Sure,
none of that belongs here.
sure.
That all belongs before the planning.
But just in terms of why I feel aggrieved.
And again, it's just a use classification, not the actual project.
I don't believe they should be in, well, you see what I have in my application. I don't need to repeat myself.
Well, but a lot of what's in your application are matters to be discussed before the planning board, not here.
Sure.
In agreement with adjourning this until?
Yeah.
Yeah. Yeah, well, let me just, so you are fine with adjourning this till next month, so we can reach a decision on the timeliness of the application.
Absolutely, yeah.
And then, depending on how that goes, we will either, just so you're clear, we gotta do some fact-finding here, and when we come back next month, one of the possible outcomes is that we refuse to hear this appeal.
I understand.
So, I'll make a motion to adjourn.
Till next month.
So we have a motion to adjourn until April 6th. To pick this matter up again. I'll second that. Tim seconded.
Yes.
And I wanted to go on record that this is on mutual agreement between the applicant and the zoning board of appeals.
Yes.
Yes.
Right, Joe, and I vote yes. I apologize that we accomplished a whole lot of nothing tonight.
Came up with
What?
enough
Unfortunately, is not routine business for us.
Very good experience.
Okay.
That's the That's the
All right,
road.
let's finish up here. We need to approve the draft minutes from the February 2nd, 2026